Every important legal case has a fundamental decision that precedes all others, a choice made by the lawyers initiating the case that determines the evidentiary standard they must meet, the measures they can pursue, and the institutional framework within which everything that follows will be judged. Do you agree with this? Leave your comment below and don't forget to like the video. Let's go to the video.
I am announcing that today we are filing a lawsuit against Donald Trump for violating the law as part of his efforts to generate profits for himself, his family, and his company. The complaint demonstrates that Donald Trump falsely inflated his net worth by billions of dollars to unjustly enrich himself and to cheat the system, thereby cheating all of us. He did this with the help of the other defendants, his children, Donald Trump Jr., Ivanka Trump, and Eric Trump, and former Trump Organization CFO Alan Weisselberg. And
let me annotate the specific documented elements from that announcement with the precision they deserve. First, the scale of the investigative foundation: 65 witness interviews, millions of documents reviewed, a 222-page complaint, 3 years of investigation. I want to hold those numbers against the nature of the fraud alleged because the investigative scale reflects the documentary density of the case. The fraud James alleged operated through financial statements, documents submitted to banks, insurers, and counterparties. Those documents existed in the files of the institutions that received them, in the Trump Organization's internal records, in the accounting systems maintained by Weisselberg and Mazars USA. The case was not built on informants or surveillance. It was built on documents. The 3-year investigation was fundamentally a document review and reconstruction, tracing the financial statements through the institutions that received them, comparing the stated valuations to independent appraisals and county assessments, and identifying the specific adjustments that produced the gap between what was claimed and what was accurate. That documentary foundation is analytically significant because it made the case's evidentiary architecture unusually durable. Documents do not change their testimony. They do not recant. They cannot be cross-examined into inconsistency. The 65 witnesses provided context and explanation for the documents, but the documents were the case. And the documents were, as James stated, in the millions. Second, the named defendants and what their inclusion established. James named not just Trump and the Trump Organization, but 3 of his children: Donald Trump Jr., Ivanka Trump, Eric Trump, and Alan Weisselberg. The inclusion of the children is analytically significant as a structural decision. It alleged that the fraud was not the conduct of a single individual operating alone, but an organizational practice involving multiple senior participants across the family enterprise. The inclusion of Weisselberg is significant for a different reason. He was the CFO, the person who prepared the financial statements. His knowledge of the gap between stated and actual values was, by definition, complete. He was not a bystander who signed documents prepared by others. He was the person who assembled, certified, and transmitted the documents that constituted the fraud. Third, the 3 documented purposes of the inflated valuations. James identified 3 specific documented purposes for which the inflated statements were used: to obtain more favorable loan terms from banks, to satisfy loan covenants requiring minimum net worth, and to obtain higher insurance coverage at lower premiums.
Organization Controller Jeffrey McConney. Mr. Trump and the Trump Organization repeatedly and persistently manipulated the value of assets to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company, to pay lower taxes, to satisfy continuing loan agreements, and to induce insurance companies to provide insurance coverage for higher limits and at lower premiums. This conduct was all in violation of Executive Law, Section 6312, which gives the Attorney General broad and special powers to go after persistent and repeated fraud and illegality. As part of demonstrating illegality under that section of Law 6312, we show that they violated several state criminal laws.
The trial produced 3 documented defense arguments, each of which Engoron addressed with formal judicial findings. I want to analyze each precisely because Engoron's rejection of each argument is a documented legal determination, not merely a judicial preference, that carries analytical weight beyond this specific case. Defense Argument 1. No victim, no fraud. Trump's central substantive defense was that no bank had actually lost money on any transaction with the Trump organization. Deutsche Bank was paid back, the loans performed. The lenders were sophisticated institutions with their own due diligence capabilities. In Trump's documented formulation, everybody knew what was happening and nobody was hurt. Engoron's documented rejection of this argument rests on a precise point of fraud law. The fraud occurs at the moment the false statement is made and relied upon, not at the moment a loss is realized. The fraud is the misrepresentation. The harm is the economic transfer produced by the misrepresentation, the lower interest rate, the higher loan amount, the covenant compliance maintained through false representations. This is not a judicial invention. It is the settled legal principle behind fraud law's existence as a category distinct from breach of contract. If fraud required proof of actual monetary loss to the deceived party, the entire category of fraud liability would collapse into the subset of cases where the deception happened to produce a catastrophic outcome for the deceived party. The fraudster who deceives a bank into extending credit on favorable terms but happens to repay the loan would escape liability, while the fraudster whose victim defaults would not, despite the identical culpable conduct. Engoron's documented holding, the economic benefit to Trump, the documented $168 million in reduced interest from Deutsche Bank alone, as I established in episode 4, is the direct economic transfer that constitutes the harm. The bank was denied the benefit of the bargain it would have made had the true values been disclosed. Defense Argument 2. Due diligence by sophisticated counterparties. Trump's second defense was that Deutsche Bank is a sophisticated financial institution with its own risk management, its own analysts, and its own ability to verify the representations in a borrower's financial statements. If Deutsche Bank chose to rely on Trump's stated values without conducting its own independent appraisals, that is Deutsche Bank's choice, not Trump's fraud. Engoron rejected this explicitly and on documented legal grounds. The fraud is the false statement submitted by the borrower. The lender's decision to rely on it, or the lender's theoretical ability to conduct independent verification, does not transfer the legal responsibility for the false statement from the person who made it to the institution that relied on it. The legal principle underlying this rejection is the same principle I documented in episode 11 in the context of the same lender defense in the mortgage fraud analysis. Fraud is committed by the person making the false statement to a financial institution. A lender's failure to independently verify a representation does not constitute a defense to fraud by the person who made the false representation. Defense Argument 3. Professional reliance by the Trump children. Eric Trump and Donald Trump Jr. argued that they relied on professionals, Weiselberg and the accounting firm Mazars, who assembled the financial statements, and that they could not be held liable for valuations they did not personally prepare. Engoron rejected this defense through a documented finding about what the professional reliance doctrine requires. It is available to executives who genuinely do not have access to the underlying facts. It is not available to executives whose level of involvement, seniority, and documented review of the financial statements made ignorance of the valuations implausible. The children signed documents, they transmitted documents. The documents they signed and transmitted contained the inflated valuations prominently. Engoron's documented finding, executives of their stature and involvement could not credibly claim ignorance of valuations that appeared in documents they reviewed, signed, or transmitted. A statutory interpretation holding. The August 2025 Appellate Division ruling, partially reversing Engoron's judgment while upholding the core fraud finding, is analytically the most important element of the case's final chapter, and I want to give it the precise statutory interpretation analysis it deserves. The appellate court upheld fraud liability on the core bank and insurance claims. It found that the false financial statements submitted to Deutsche Bank and to insurance companies did constitute fraud under Section 6312. The core holding, that the Trump Organization engaged in systematic financial fraud as a matter of business practice, survived the appeal. What the appellate court reduced was the penalties scope in categories where the deception to harm chain was less directly established. Specifically, for categories of claims involving properties where the alleged overvaluation did not result in a directly harmed transaction counterparty, where the false statement was made, but there was no specific documented transaction in which a counterparty relied on it to their detriment, the appellate court found the disgorgement remedy exceeded what Section 63 to 12 specifically authorizes. This is a statutory interpretation holding, not a factual reversal. Let me be precise about what that means. A factual reversal would say, the facts presented do not establish that fraud occurred. Engoron's factual findings about what the financial statements contained, how they compared to independent valuations, and how they were used were not reversed. They are in the permanent record. A statutory interpretation holding says, assuming the fraud occurred as found, the specific remedy the trial court imposed exceeds what the statute authorizes for this category of claim. Section 63(12) authorizes disgorgement of profits from fraud. The appellate court found that for categories where the direct transaction harm connection was not established, the full disgorgement calculation exceeded the statute's reach. The distinction matters for the permanent record. The fraud is documented and upheld. The financial consequence is reduced. Both are true simultaneously, which is precisely the structural narrowing paradox I identified in episode 14. The final penalty amount, the specific dollar figure that emerged from the remanded recalculation, was lower than Engoron's $354.9 million. The business restrictions were reduced in scope, and the core fraud finding, that the Trump Organization engaged in persistent and repeated financial fraud as a matter of business practice, survived every level of appellate review. The complete civil fraud arc, 5 episodes, 1 documented record. Across 5 episodes of this series, I have analyzed different dimensions of the civil fraud case. Let me trace the complete documented arc as a unified analytical record. Episode 1 established the foundational numbers and framed the civil fraud case as one node in a multi-court accountability network, the first analytical treatment of the Engoron judgment's significance. Episode 4, the forensic analysis of McConney's testimony, property by property, methodology by methodology, the aggregate pattern, every adjustment in the same direction, always upward, without exception. The 3-mechanism framework I developed in today's Block 3 completes what Episode 4 began. Episode 10, the enforcement sequence, the Westchester lien, the 30 insurance company rejections, the fire sale bind, the bond reduction through Don Hankey, the court-appointed monitor, the appellate penalty recalculation, the gap between the legal findings' permanence and the financial consequences' contestability. Episode 14, the structural narrowing paradox applied to both the civil fraud case and Trump vs. Anderson simultaneously. The accountability confirmed, remedy reduced pattern identified as a systemic feature of the legal system's engagement with this case. Episode 15, today, the complete institutional arc from September 2022, filing through August 2025, appellate resolution, the statutory choice that determined the framework, the inflation scheme's 3 mechanisms, the defense arguments and their precise documented rejections, the appellate holding as a statutory interpretation that preserved the core fraud finding while reducing the penalty's scope. Together, these 5 episodes document the complete institutional record of the most consequential civil fraud case in modern New York legal history. The documented conclusion, across all 5 analyses, the fraud is established, permanent, and documented at every appellate level. The financial consequence is reduced, contested, and ongoing. The man who was found to have engaged in systematic financial fraud as a matter of business practice is in the White House. The accountability gap, what the complete arc shows. The source material's closing question, is this a vindication of the legal system, a demonstration of its limits, or both at once, is the right question. Let me give it the precise analytical answer the complete 5-episode record supports. The legal system vindicated. The investigation produced a documented evidentiary record of millions of documents and 65 witnesses. The trial produced a documented judicial finding of fraud by a judge who reviewed the complete evidence and reached a formally entered conclusion. The appellate review upheld the core finding unanimously while reducing the remedy scope through a documented statutory interpretation. Every level of institutional review confirmed the fraud's occurrence as a documented fact. The legal system's limits demonstrated. The financial consequence was reduced from $354.9 million through a documented statutory interpretation that the same legal vehicle James chose, Section 63(12), required. The business restrictions were reduced in scope. The delay mechanisms I documented in Episode 14's delay strategy analysis allowed the election to intervene before final enforcement. The man who was found to have committed systematic fraud is governing with the fraud finding on his permanent record and a reduced financial penalty under recalculation. Both simultaneously, the case produced precisely what it was designed to produce within its statutory limits. A documented permanent finding of fraud, a reduced financial penalty within those limits, and a shorter business restriction. It produced precisely what the structural narrowing paradox predicts: accountability confirmed, consequence incomplete. What it did not produce, and could not produce within its statutory framework, was the equivalent of Nixon's resignation, the final, irreversible institutional moment in which the documented findings produce a consequence so complete that it terminates the subject's ability to exercise the power they hold. That gap between the documented finding and the adequate institutional consequence is the analytical question the full 14-episode series has been building toward. And as I stated in episode 13, November 2026 is the structural mechanism through which the gap between documented findings and adequate consequences is most directly addressable. Through the congressional track that remains the last institutional mechanism the series has not yet seen reach its threshold. Let me state what the complete documented arc of the New York civil fraud case establishes. 1. On September 20th, 2022, Letitia James filed a 222-page complaint against Trump, the Trump Organization, Donald Trump Jr., Ivanka Trump, Eric Trump, and Allen Weisselberg under Executive Law Section 63-12, a civil fraud statute designed for persistent, repeated fraud embedded in how a business operates. The statutory choice determined the evidentiary standard, the remedy scope, and ultimately the appellate outcome. 2. The inflation scheme operated through 3 documented mechanisms: false size, Trump Tower triplex stated at nearly 3 times its actual square footage, ignored restrictions, Mar-a-Lago valued at up to 40 times its assessed value, while deed and conservation restrictions legally prevented the residential development use that justified the inflated figure, and hypothetical development, Seven Springs valued at $291 million based on 18 homes that were never planned, approved, or built. Every adjustment across 23 properties over 10 years in the same direction. Always upward, documented systematically in the record McConney described in his testimony. 3. The inflated statements were deployed for 3 specific documented purposes: securing more favorable loan terms from Deutsche Bank, satisfying loan covenants requiring minimum net worth, and obtaining higher insurance coverage at lower premiums. The economic benefit from the Deutsche Bank relationship alone was documented at $168 million in reduced interest. 4. The trial produced 3 documented defense arguments, each of which Engoron formally rejected. No victim. Rejected. Fraud occurs at the moment the false statement is made and relied upon, and the economic benefit to Trump constitutes the corresponding harm. Sophisticated counterparty due diligence. Rejected. The borrower's legal responsibility for a false statement is not transferred to the institution that relies on it. Professional reliance. Rejected. Executives of this stature and involvement cannot credibly claim ignorance of valuations that appeared in documents they reviewed, signed, and transmitted. 5. Engoron's February 2024 judgment, $354.9 million. 3-year New York corporate officer ban, testimony described as entirely disconnected from reality, was appealed to the appellate division. 6. In August 2025, the appellate court upheld fraud liability on the core bank and insurance claims. It reduced the penalties scope for categories where the deception to harm chain was less directly established under Section 63(12)'s specific statutory requirements. The core fraud finding, persistent and repeated financial fraud as a matter of business practice, survived every level of appellate review. The financial consequence was reduced, the fraud finding was not. 7. Alan Weiselberg, who prepared the fraudulent statements for decades, pleaded guilty to criminal tax fraud, testified at the civil trial under a cooperation agreement, and was subsequently prosecuted for perjury related to that testimony, is the case's most documented insider witness. His credibility paradox, essential for the mechanics, attackable on the cooperation basis, is the case's most complex evidentiary dimension. The source's closing formulation is precise, and I will adopt it. What is not in dispute is what was proven. The court said so. The Trump Organization engaged in persistent and repeated financial fraud as a matter of business practice for over a decade. That is a documented judicial finding, upheld at every appellate level, entered into the permanent record of the New York court system. The penalty for that fraud is reduced and under recalculation. The business restrictions are reduced in scope. The person who ran the organization that committed the fraud is in the White House. That is the complete arc. It is documented, it is precise, and it is part of the permanent institutional record that the full 15-episode series has been building. The record that does not expire, does not get deleted, and will be there when every subsequent accountability reckoning examines what this period produced. This is Matthew John Turner. The question the complete civil fraud arc leaves, across 5 episodes of analysis, is the one the source itself closes with. Is a legal system that can find fraud without fully collecting it and can confirm wrongdoing without preventing the wrongdoer from exercising the most powerful office in the country, a system that holds power accountable, or one that produces accountability on paper while protecting power in practice? The honest analytical answer, after 15 episodes, it is both. The accountability is real, documented, and permanent. The consequences are incomplete, reduced, and ongoing. The constitutional design was not built for this specific scenario, and November 2026 remains the structural mechanism through which the gap between documented accountability and adequate consequence is most directly addressable. Go read the Section 63(12) complaint in full. It is public record. Read Engeron's February 2024 judgment. Read the Appellate Division's August 2025 ruling, specifically the sections on the disgorgement remedies statutory scope. Compare the fraud-finding language at each appellate level. The documents are public, the record is complete, and the documented gap between what was found and what was collected is the clearest single illustration of what accountability looks like when it engages with sufficient resources, sufficient political support, and sufficient procedural sophistication to convert every accountability mechanism into a contest over remedy. I will see you in the next one.